Hello, this is Kelly Allen. I'm going to spend a few minutes discussing adult guardianship in North Carolina. Now, ideally, someone would have a durable power of attorney in place, designating an agent who would have the authority to assist himself or herself with financial issues, and a healthcare power of attorney designating a healthcare agent, the person who would make medical decisions if and when he or she became unable to manage and speak for himself. If that has not been done and someone becomes incompetent or incapacitated, the only other way for a family member or friend or concerned individual to get the authority that's necessary to assist that person is to file a guardianship petition with the courts. And there are three types of guardianship. There is guardianship of the state, which is asking for the authority to handle financial matters. Guardianship of the person, which is authority to make decisions about the individual himself or herself, their care, their health care needs and medical decisions. And then there's general guardianship, which combines the other two. So basically giving authority to handle the financial issues and the health care decisions that need to be made. The standard for achieving guardianship is that you have to be able to prove that the person you're seeking guardianship of is truly incompetent. It is not incompetent for someone to make bad decisions or poor decisions. There has to be solid medical evidence showing that this person just truly no longer lacks the capacity to make these financial decisions or to care for themselves, to make decisions about their person, their living situation, that they're completely incapable. If someone is competent but just making bad decisions, then you're not going to be successful in a guardianship petition. But once you've established that incompetency, you've established that there is a need for a guardian, then it comes down to who is going to be appointed. And generally the person that's filing the guardianship petition is asking that the clerk of court or the judge appoint himself or herself. So, but that's not an automatic thing. The clerk or the judge has to decide that you are the person who is in the best position to handle that responsibility. And a lot of times the clerk wants to have two different people, maybe one person that's handling the financial aspect and one person that's handling the health care and personal care aspects. So it's all up to either the clerk or the judge, whoever is making that decision, to decide who the most appropriate person is to appoint as the guardian.